My name is attorney Aaron Swift. As the guy said, I'm down here in Florida. Brief introduction before we get to the questions, just to set the table. So I own two law firms. Our flagship is down in St. Pete, Tampa area in Florida. And we just launched a national firm called Swift Law North, and that's based out of DC. And with partners like these great guys, Mike and Dave are some of our flagship partners with this new venture. We are building a nationwide network of attorneys that we're helping to connect you all, the consumers, with attorneys in your home states that can sue these debt collectors, credit reporting agencies, credit card companies, background check companies, landlords, repo agents, all of them. You name a company that's in the financial sector, we want to sue them because they all break the law. And you all don't even understand the power of what I can do for you and how important it is. So also, before we get to the questions, I want to thank Mike and Dave. They're incredible at what they do. You guys have come to the right place, the right platform, and through their help, connecting to us and then connecting you to lawyers across the country, we're going to do three main things. That's keep this in mind. Number one, we're going to fix the problem. That's always the number one goal. We want to stop debt collection harassment. We want to fix your credit reports. We want to clean up identity theft problems. We want to get old inquiries that shouldn't be there off. Everything you can possibly imagine. That's number one. Number two, I want to put money in your pocket. This whole program is built upon fixing the problem, but then compensating you for it. These companies make more money than they know what to do with. We're talking billion-dollar profit margins every year with a B. We want a piece of that pie because we deserve it. So number two is we want to put money in your pocket for these problems. It could be $1,000, it could be $100,000 or more, depending on the type of case. And then number three, the bad guys have to pay me. That's what's so important to know. No one in our program, absent very similar or small circumstances, ever come out of pocket to pay me. If I am suing someone on your behalf, a debt collector, a credit reporting agency, a background company, you don't pay me, nothing out of pocket. We take it on a contingency fee basis, which means we only get paid if we win. So number one, we fix the problem. Number two, we're going to put money in your pocket, maybe forgive the debt if it's legitimate, get rid of it if it's not. And number three, the bad guys pay me so that you don't have to. So thanks, excited about these questions, and let's get started.
Ooh, we're about to permanently remove some debt. Man, it's about to be dope. So first things first, we have Miss Lisa. She's a 700 plus Blueprint member, and she is being sued, and she wants some specific help.
Okay, and let's set the stage for how we do this. If you're going to ask me a specific question, I need to know your name and your state. That's the initial information, because if you're in Florida, I can give very specific legal advice. If you're not in Florida, I'm going to give advice, but it's going to be more of a general nature. So I just need your name and then the state you're in. So, all right.
Are you ready?
Miss Lisa?
Yep, I'm here. Can you hear me? Yes. So my name is Lisa Gassett. I live in Texas.
Okay.
I just recently moved here 3 years ago. My debt was from when I was living in California from Credit One Bank, but LVNV Funding now owns it. And so it was almost the 4-year mark. It's almost the 4-year mark, I think, in like March, actually, when we go to court. So one day I just opened my door and there's a lady there serving me for my Credit One credit card from LVN Funding.
Got it.
I responded to my deal at the courts. I was told that you're supposed to kind of fight back on it, ask for more validation that if they really own my debt. Because in the paperwork they gave me, it only shows that they bought a bunch of, says accounts, and then also just a statement of what the credit card was spent on.
Right.
So I asked for more information, more validation, a binding contract between both parties. is the court supposed to send me something back to a response, or is that the only response I get was when I go to court?
Well, that's a great question. So first, quick disclaimer, since you're not in Florida, I'm going to give general advice that you
Okay.
should find applicable and helpful.
Okay.
And Lisa, this also gives me an opportunity to talk more generally about these types of lawsuits, because I think it can apply to other people here watching live today. It happens a lot in a lot of people in this space. So what you're describing is what's called a debt buyer situation, or we call them junk debt buyers.
Right.
LVNV is one of such companies, a huge one. LVNV is owned by a parent company called Resurgent Capital, and they're $1 billion corporation. So think about that. They're spending enough money to buy old debt such that then when they collect it, they're bringing in $1 billion a year of revenue with a fee.
Right.
Others you may heard of, like Midland Credit is another big one, MCM. But those are all junk debt buyers, or they buy what's called portfolios of accounts. So Lisa, you mentioned a couple very important things I want to talk about here with these types of cases. So number one, if it's a first party creditor suing you, it's always a lot more difficult.
Okay.
So you're in a better position than some consumers because you have a debt buyer.
Right.
And so that means at least one time there was allegedly a change of ownership of your debt. You did mention it was Credit One originally.
Right.
But what's crazy, even though it went from Credit One to LVNV, I can almost guarantee there's 3 or 4 more steps behind the scenes. And the hard part for these companies is they have to prove every one of those steps. So what you described as, the documents you're getting back, there's some other things that you're going to want. One is called a forward flow agreement. A forward flow agreement is what's basically the master contract. That's between LVNV and Credit One Bank. Credit One Bank probably sold 5,000, 10,000, 20,000 accounts along with yours at one time, one batch. I'm sorry, Lisa, go ahead.
Yeah, that's what it looks like when it says they bought accounts. It just says, that sounds like a bunch of them.
Right. And yours is one of them. So sometimes it's like a needle in a haystack. And if you're doing the right thing by fighting back, these things can be won very easily if they're junk debt accounts. And Lisa, what I'd like to do is connect with Mike and Dave after the program, because again, this whole program is about connecting you all to lawyers. If it's me, amazing. I love it to be. We have coverage in many states, or it's going to be one of my, amazing partners. And I've got great partners in Texas. So rest assured, there are good defenses to these cases. Like I said, they have to prove the change of ownership the whole way through. There are specific types of documents that you're going to want to either get or ask for. And then another important thing about these junk debt buyer cases is, let's talk numbers. Lisa, I don't want you to tell me any specifics because it's private, but let's just say they're suing you for $5,000, or anyone's being sued for $5,000. You had a $5,000 debt for Credit One Bank, and now it's with LVNV. From my past experience, and I've been doing this going on 14 years, I've seen thousands of these contracts. They pay between 3 and 12% of the original amount to buy your debt. Think of that. 3 and 12%. And it depends on how old the debt is, or
it's almost 4 years. Originally, the credit card was like $400, and now it's up to $832.
Which makes sense because of all the interest and late fees and other things that accrue. So $400 to $800, they probably paid less than $80 for that account.
Yeah.
So what that means is it gives you some leverage to negotiate. And junk debt buyers are always willing to take less than the full amount. In my experience, sometimes they'll take low as like 30% of the debt. Now, on one hand, they look like Santa Claus. Hey, we're giving you a 70% discount. We're the greatest people on earth. Well, pardon my language, but screw you. You paid 3% and now you're charging me 30%. You're going to be on your yacht with that markup.
Right.
So it gives you a lot of leverage. And these types of cases, again, it's very important to understand. Try to fight back. They don't want you to fight back. And Lisa, let me real quick, and I'm going to ask you another thing specific, but just generally speaking, you're doing the right thing because all they want to do is to get you to default. They don't want you to show up to court. They don't want you to fight back. They don't want you to answer because all they want is a default. Then they get everything they're asking for plus more, and they get to garnish either your paycheck or your tax return. So just fighting back is always a good thing. It gives you additional leverage. So Lisa, you're doing the right thing by that. And sorry, I interrupted you. Go ahead.
That's okay. Yeah. I was also asking too, because I also, even though I was served, I don't know if this is valid to do it after you've been served, but I also sent them another letter of validation. And they still send me the same thing, the statement through the resurgent, and then the statement of what you spent on your bill and stuff. They still sent me that. Then later on, I end up sending a deceased insist letter, and they responded to that. Is that considered still a violation or not? If I've been served already?
That's a great question. So being served doesn't stop many things. It doesn't stop their right to keep collecting from you. They can still call, they can still send you things, up until sending a cease and desist, for example, like you just described. But being served and being sued doesn't really stop many other clocks or timelines. The one it does stop is the statute of limitations. So as you mentioned, the debt was originally from California, so it's 4 years. So it does sound like they sued you. They don't have to get their judgment by 4 years. All they have to have done is filed their lawsuit within 4 years. And it sounds like they have done that.
Yes.
So that would be a successful defense that it's past the statute of limitations, but there are plenty of other options in the toolbox to try to defeat them. And let me also say, Lisa, that if you don't defeat them, another strategy is to get onto the lowest settlement that you can, because one of the things that I love to do is sue these idiots on the back end.
Yeah.
So these companies get so greedy and lazy that once you enter into an agreement with them, like everything else goes out the window. And what they often do will credit report erroneous information after the settlement. So in a situation like yours, let's just say, for example, that you negotiate a $400 settlement paid over 10 months. You pay them $40 a month for 10 months. That might be something they would absolutely, you should offer that. I would recommend. They might take it. But guess what? So you're going to pay for 10 months, the $40 a month. And then I'm going to say to you, hey, Lisa, I want to talk to you in month 11 or month 12, because we're going to check your credit reports. And I can almost guarantee you, they're still going to report that you owed the $800. They're not going to be showing your settlement payment. They're not reducing your balance. So even if we can't defeat them right away in the defensive case, we might be able to go after them in the long run. So that's a really fun strategy. And we do that all the time. So,
that's awesome.
Any more specifics? I would say let's connect you with a Texas attorney. But it was a great first question because we got to talk about a lot of things: the junk debt buying industry, some strategies to use, and defending. But let me also say something very important for Lisa and everyone else. Remember when I talked about there's some small circumstances where you do have to pay the attorney. When they're defending you, it's often that case. So if you're being sued by a landlord for eviction, if you're being sued for an old credit card debt, or you're being sued for foreclosure, you do have to pay the attorney's fees, because it's not like the offensive cases where the bad guys get to pay us per the statute. Now, we're incredibly reasonable. We understand you're in this position, but there is always a little bit of skin in the game. And we try to get that back for you anyway, like I said, in the long run. But just keep in mind, if someone's being sued, it doesn't mean that someone's going to represent you for free. Sometimes they will if it's egregious enough. Like, for example, if a case comes to me past the statute of limitations, I don't charge my clients anything because I know I'm going to win it, and then they're going to have to pay me because I'm going to sue them under the Fair Debt Collection Practices Act because they sued someone past the statute of limitations. That's a violation. So anyway.
So is it best I offer a letter of settlement before, or do I, when I show up to court, then offer to do like the $400 for the $40 a month?
That's a great question. And I'm so glad you asked it. You should offer that soon. because the
Okay.
longer it goes and the closer it gets to court, they're going to have to put some time and resources into it,
Okay.
and they're going to be less likely to take a lower amount. So
Okay.
strike while the iron's hot and early.
So
And
just send
another
them.
important thing for Lisa and everyone else, if you ever negotiate a settlement, whether that's because you've been sued or not, you just settle a debt with a debt collector, always get it in writing. They will try not to. They don't like to put these in writing because that gives you a lot of proof and leverage, but always get a settlement in writing, whether that's you're settling a lawsuit or you're settling a debt with a debt collector on the phone or via email.
So do I call in on that, or do I send them a letter certified and this is what I could do?
Call first.
Okay.
You call, and then if you do, and another thing, let's talk about strategies here.
Okay.
Never started offering 50%.
Okay.
Always start offering like 10%.
Okay.
Because remember, at 10%, that might either be breaking even or just making a little bit of money. They're never going to take 10%, but you just want to start lower.
Okay.
Then they're going to offer, we'll knock off 10%. You're going to say, well, I can't pay 90%. I can pay 20%. And then maybe you somewhere in the middle. But that's why it's always better on the phone. You can have a couple of quick phone calls. Letters just take too long and they get lost.
Right. Yeah. Well, thank you so much. I appreciate your information.
Absolutely. Thank you, Lisa. We appreciate you calling in.
Yes, thank you so much. You guys, I'll enjoy the rest of your guys' chats. Thanks.
All right. Thank you. Hey, Aaron.
Hey, Mike, answer some questions first, and then we're gonna bring a few more, next people.
Okay. I was about to say, man, Aaron, that was very good, man.
I'm happy to be here. These are awesome.
Well. No, I was saying answer some people's questions. No, the questions you answered help some people in the chat.
Of course.
All right, I got one right here. I'm pretty sure it's kind of the same thing. Being sued by a debt collector, I responded to the courts. They told me to respond to the collection agency.
Yeah, that's a great point. So it's very important to understand when you've been sued, there's now two separate processes taking place. There's the court case, which has deadlines, it has rules, it has standard procedures. And then there's still the debt collection that can happen outside of court. When you say that you responded to the courts, Trish, what that's telling me is if then they told you to talk to the collection agency, it tells me that it wasn't an official proceeding yet. It wasn't the final hearing. And what it probably means is that you were asking for certain information from them or wanting to settle it or discuss with them. The only time you'll use the courts is when there's a set hearing or a very set specific deadline. So again, it's two different processes. So if someone has sued you, it doesn't mean you can't be talking to them outside. In fact, courts encourage it and require it like they did with you, because the courts follow very specific steps. You file the case, it has deadlines, they've got their calendars, you go to these hearings and there's 100 other parties waiting. So yeah, the courts want parties to always talk to each other unless it's a very specific court event. And that's to encourage settlement and to finding ways to move forward, putting obstacles aside to resolve the case. So that's why you're being told to talk to the collection agency. The only time you'll go through the courts is a specific court event, like a hearing or a deposition or something like that.
Okay. And I have one right here. Do you have partners in PA?
Red, I grew up in Pennsylvania. I'm an Eagles fan, although the last 2 weeks haven't made me happy. I've got a lot of partners in Pennsylvania. My family's still there. I'm going to be up in Pennsylvania here in a couple of weeks. So I've got lots of them. Pennsylvania is a great place for me. Like I said, grandma, brothers, all up there. So Pennsylvania is a great state. And mind you, and I was talking to Mike and Dave before we all jumped on, the goal of this program is to help every single state. Now, if someone here is from North Dakota, I can't promise I have a good partner in North Dakota lined up just yet. But big states with a lot of population, we have partners everywhere.
All right, great.
Including outside Philly.
Oh, okay. All right, Dave, can we bring up? Okay. Can we bring up the next guest, Dave, or do you want me to ask another question? Oh, there she go. What's going on, Robin?
Hi, I was trying to find me a charger because now my battery is dying. But we're gonna try to get through it.
Hi, it's Robin.
Hi. Yeah, I see you talking about my Eagles.
Right.
That's okay. That's okay. We have Monday night coming up, so
Yeah, they flexed it.
we
Seahawks.
gonna, we
So
gonna
are
get.
you in Pennsylvania, Robin?
I am. I'm right outside of Philadelphia. I'm in Lansdowne, Pennsylvania, and so
Excellent.
like if I go up the street and around the corner, I'm in Philadelphia.
Yeah, I grew up outside of Harrisburg in the Carlisle
Oh.
area.
Okay. Well, then we friends then.
Right.
Well, thank you, Dave and Mike, for allowing me to be on. Thank you, Aaron.
Mhm.
Like I said, I hope my battery doesn't die. But so I have a couple of questions.
Okay.
I've been in this credit space now almost. This coming March will be 2 years. I began last year, just wanting to fix my own credit.
Mhm.
I joined one of those credit groups on Facebook, and I heard them say, "Look up Dave Cousins." And so I did that, and then I started following Dave, and I started doing a lot of things that he put in his content, and a lot of it, like worked, like a lot of it. And so now I'm basically, well, first of all, I've cleaned up everything. I have one thing left on my report that I'm trying to get off, and I just want to know. I mean, because I'm not the one to take no for an answer. So, when they say verify, okay, prove it to me. But I just want to know if I'm using the information the right way, or if I'm using it in the right contents. So, from what my understanding is, that you can get anything deleted from your credit report, including open accounts. I have a car note, and I don't want it on my credit report. And so I've sent them like 3 letters asking them to remove the account from my credit report. And so I'm not saying that, I'm not going to pay. I'm just saying that I don't want the account reported. And so I based it off of the Graham-Leach-Bailey Act. And as far as them giving me my disclosures, letting me know, or giving me the opportunity to opt out of this information being reported. So I put that in the letters to them. And each time they sent a response back saying, we are reporting this account correctly, and it's going to continue to report. And so now, so I want to know, A, did I use the right information when I sent them the letter? And B, can this be deleted from my credit report?
Well, Robin, you bring up some really important points that we're about to talk about. So, number one, anything can be deleted.
Okay.
Because I'm going to explain to you what the dispute process actually looks like behind the scenes. That's the good news.
Okay.
The bad news is, no, you don't have a proper basis to get that deleted. That act doesn't say that. And more importantly, your contract with your car note company requires credit reporting. And unless they report inaccurate or incomplete information about that account, there's nothing we're going to be able to do legitimately based on the law. But let me explain how, when I say that anything can be removed, because when I describe to you all what actually happens behind the scenes when you dispute something, it's going to make you fall out of your chair.
Okay.
So let me give a real quick 10,000 foot view of what it means when you dispute. Okay. So there's 4 to 5 primary methods that you can dispute right now. You can send a letter. You can do it on the phone. You can send a fax. You can do it through the CFPB. And you can also do it through the FTC in certain circumstances.
Okay.
So I send a letter, phone call, fax, something to these bureaus. Let me explain this process. So I can send a 20-page letter, and they're still going to distill it down to 3 characters. I can send a 6-minute voice, conversation about what's going on. Every dispute is categorized by these companies down to 3 characters. It's usually a letter and then 2 digits, 2 numbers. And that's supposed to tell what your dispute is about.
Right.
And so what happens is all your information gets down to those 3 characters. And that's done by a computer. Right now, it's done by a lot of AI. Before they were sending stuff overseas, and they still do that, which I'm going to explain. So you start a dispute. You say, hey, I don't want this on my credit report. I don't give you permission. I'm opting out. And again, that's not what that statute says. But nonetheless, a computer read that information and took it down to a letter and 2 digits. And then it ships that 3-digit code to the computer that's furnishing the information. That's the debt collector or the car note company. And all it does, its computer looks at those same 3 pieces of information and says, oh no, yeah, we're reporting right, and shoots an information, just an information signal back that says, okay, verify. And usually that's just 1 digit, like a 1 or a 2 or 3. There's seldom any human involvement. There's no concerning review of the information. It's almost always automated. So that's the reason why real disputes that have real validity, if there's an ID theft issue or past statute of limitations or you settled an account, that's why they verify everything, is because it's almost always just one computer talking to another. Now, the reason why I ultimately said it can be deleted is because those systems get overwhelmed. And when the computer queues fill up, it does get sent to live agents in the Philippines or in India and some other countries, but they're all overseas. And that's only when there's an overflow. Those people make mistakes. They might look at a letter and say, hey, that looks impressive. She cited a statute, and just hit the delete button because they're getting paid 37 cents an hour and they don't care. So that's why I started by saying everything can be deleted, because depending on the person or the computer or the process, that's going to determine who is actually doing the quote investigation. And this is the funny part. The law says you have to perform a reasonable investigation.
Right.
Well, how is that reasonable when it's just one computer talking to another about 3 digits? So great question, Robin. It allowed me to kind of talk about the dispute process. It is set up to fail. It's why I have a job, because if all the disputes worked, I couldn't sue them. But yeah, the system is set up to just agree with the original reporter. And let's talk about why. Do you know how Experian, Equifax, TransUnion, they make their money? Do you,
Well,
have you ever paid them?
I believe I know how. Yeah, they make their money because companies pay them to report the information.
Amen, Robin. It's like we set that up before tonight. That's exactly right. They make a little bit of money when you pay them for those monitoring products that you should never do, by the way. Never, ever. But we can talk about that in a minute, but never enter an agreement with these companies, because they're going to make you arbitrate. They're going to sneak fine print against you. That's going to take rights away from you. But yeah, they make their money, the billions of dollars, because Capital One is paying them $10, $20, $30 million a year. Every time Capital One sends them information about you, they have to pay them a little bit of money. So who are they going to agree with? If you reach out to them and say, I'm right, Capital One's wrong, but Capital One is paying them $10 million a year, are they going to agree with you? Or are they going to agree with their partner? So the system's set up to fail. It's why lawyers like me are so important, to get connected to people like you and consumers and other, people like Dave and Mike, because the system's set up to fail. And as a consumer, you're going against billion-dollar corporations who hire $1,000 an hour lawyers who have glass mansion firms in the biggest cities in the world. And it's David versus Goliath. But yeah, they don't make their money from me or you. They make their money from the companies. So of course they agree with them.
Right.
Set up to fail. So
Okay. So I'm trying to get my other question in before my battery, because I'm literally on red.
all right.
Okay, so with that being said, right? So Equifax, TransUnion, and Experian. What about check systems? So check systems, I know they're a specialty,
Right.
credit reporting agency. And so to get out of check systems, you go through the dispute process. And so what if you've disputed and they send you a copy of the contract from the bank, but the account is charged off?
Great question.
So how do you get that off?
So it kind of goes back to my previous answer. It depends on the nature of what they're reporting. So you brought up a really good point. So everyone knows about the big three credit reporting agencies, Equifax, Experian, and TransUnion. They're the ones that everyone's most familiar with. But what might shock you is there's over 250 credit reporting agencies.
Mm-hmm. I know that.
And actually there's significantly more depending on how you want to look at it. But there's credit reporting agencies about whether you've ever slipped and fallen in a supermarket and sued someone. Every insurance claim that you make, there's a credit report about you.
Mm-hmm.
Every checking account, savings account, those are called demand deposit accounts.
Mm-hmm.
There are credit reports about you, and check systems is one of them.
Mm-hmm.
And so think of check systems just like the big three, Experian, Equifax, and TransUnion. When you open your account with your bank, all that fine print gave them the right contractually to report to check systems or to anyone they want to, frankly.
Okay.
And the law says as long as they report accurately and completely, there's nothing we can do about it. So if the information they're reporting to check systems is accurate and complete, other than the description I gave earlier, when someone gets overworked or it slips through the cracks, you confuse them enough that your dispute looks legitimate and then someone deletes it. It just goes back to the law says they're allowed to report as long as there's a basis for them to. And that basis is always going to be some contract, generally speaking, or you fall behind in debt, like a medical debt doesn't necessarily have a contract, but the law also says in order to debt collect, they can use a credit report. So that's how you get collections on credit reports. There's no contract necessarily, but the law allows them to do that. So the basis of any type of dispute, whether it's check systems, fishing license credit report, which exists, by the way. If you ever overfished a lake and taken too many, you take 8 bass when you're only allowed to take 6. There's a credit report that says this person, if they ever want to get a fishing license in your state, you may not want to give them that. So, but no matter what, background checks, your big three credit reports. I saw someone put in the chat here, LexisNexis. They are a massive credit reporting agency, particularly about insurance mostly. But any of these, the basis to dispute has to be the information is inaccurate, incomplete, or too old and can't be reported. Unless it's one of those 3 things, you got to get lucky.
Okay. And then one more. Early warnings. That's the same as check system?
It is. Yep.
Okay.
They're a specialty demand deposit reporting agency. That's exactly right.
Okay. So inaccurate, incomplete.
Or too old, so
Or
if it's
too-
over 7 years for bad information, 10 years for a bankruptcy, that would be the 3rd reason why.
Okay.
Chris,
Okay. Well,
Robin,
thank you very
excuse me.
much.
Yeah, thank you, Robin.
I appreciate
Thank you, Robin.
Thank you, Dave and Mike.
All
You're
right.
welcome.
Good questions, Robin. All right. Hey, Dave, I want to run through some more of these questions. Aaron, are you good?
I'm good. This is great. I'm excited.
Hey, Mike, ask one of them questions out of the documents because I'm a student loan.
I forgot. All right. Hey, Robin, you sticking around with us?
You know what? I'm making some collard greens for a company potluck tomorrow. So I'm going to check on my collard greens, but I'll be right back. But I'm still going to listen in, but you can take my face off.
Okay.
All right. Hey, Aaron, so a question is, if a client got their student loan forgiven,
Maybe. And that's a famous lawyer answer, or it depends. That's a real famous one, is responding it depends. It depends on when the late occurred. So if the late occurred prior to the settlement or prior to when it was forgiven, it sucks, but they can go back and put bad information in the past in. If they put a missed payment or late payment after it was forgiven, well, that's of course wrong, because you can't owe a payment and then miss a payment after it has been forgiven. So it is, and I hate this rule because a lot of companies will do this. After you resolve with them, you settle it or they forgive it, they do a final accounting, on their side. And sometimes that adds information to your credit report, because that final accounting is a final summary of the whole account. And so if you missed a payment 4 years ago, it may only pop up now when you finally close it, because they do a final review and they submit the final round of information back. So it could be the case that this person had their student loan forgiven. That student loan company did the final reconciliation of that account, and that made an old missed payment pop up. Unfortunately, if it's within 7 years and that payment was legitimately missed, there's nothing we can really do about that. But if they forgive a debt and then mark you late afterwards, that's of course wrong. We do that case all the time. We talked earlier with Lisa. If you settle with an account, they can't mark you late for the next owed payment, but that happens too. So really it depends. So we just need to know a little bit more about that particular question. If it was a legitimate missed 30, 60, 90, all the way up to 180 in the past, it's accurate. There's not much we can do unless it's older than 7 years, or they marked you late after they forgive it. That's a big problem.
Okay. Yeah, I think this guy said he was in forbearance and they still marked him late.
So that's different. That could be a good case. So when you are in forbearance, you don't owe money. That's what a forbearance agreement is. So if we can prove in writing the period of that forbearance, we might be able to help with that case.
Okay. And that's a good segue to the next question. Dave, you got something before I ask? Okay. Somebody asked, what are some ways that we can prove our violations?
Okay. So glad you asked that question. And it's going to be a good thing for me to talk about generally. One important thing to understand is there is a big difference between what a lawyer can do in litigation and what is successful in credit reporting and credit disputing world and credit repair. So in a court of law, which we're going to be suing in mostly federal court, we have to prove ironclad. So I'm so glad that question got asked, which means don't throw away any mail. If we're working with you, don't throw away mail from debt collectors, don't throw away mail from creditors, landlords, what have you. The credit reporting agencies, if you get mail from them, because by the way, if you hire an attorney or hire a credit repair, group, and they dispute for you, the law still says the results come back to the consumer directly. So even though I may send a letter on the consumer's behalf, the consumer is going to get the result. So the best way to prove these violations is to always keep the evidence. Let's talk about other types of violations, right? So let's say it's a phone call and a debt collector is rude and aggressive and makes threats or swears at you. Well, two things. One is that call is going to be recorded on their end. I can guarantee it. The other thing is in your state, which check your state, you may have the right to record them. For example, in Florida is what's called a two-way recording state. So I can't record someone unless I tell them. But everyone knows you get that phone call and it says, this call may be monitored for quality assurance or, training purposes. That is a notice to you that they may record. So you automatically have the right to record in the state of Florida. You don't even have to ask or tell them because they have already told you, hey, I might be recording you. You can record them. So that's another important thing. Don't throw out mail, don't delete voicemails, don't delete your call history, in your call log, because if we're going to sue debt collectors, we have to prove what they did. We either need the letter that they shouldn't have sent you, that phone call that's going to be recorded. If someone's rude to you on the phone, just take notes, and write a little date next to it. Because in a court, if I say, hey, my client took contemporaneous handwritten notes, you can see it on this notepad. It's dated that day at the same time as the phone call. Who are they going to believe? They're going to believe the consumer with these notes, or are they going to believe the debt collector saying, oh, I never threatened that. Oh, and by the way, we lost the phone recording somehow, which always happens. But how we prove these things is through evidence. And that evidence is don't throw anything out, keep notes, don't delete voicemails, especially the mail. And then prove the violations for the credit reporting. That really depends on the nature of the dispute. If you're saying I didn't pay late and they marked me late, well, show me your clear check. Show me the payment that you submitted through the online portal on the 29th day. Sometimes these companies get greedy, right? You have 30 days to generally pay until they mark you late. Well, companies have been sued for send the payment on the 29th day. Well, guess what? It goes to the bottom of their pile. So by the time they get to, it's been 32 days. They can't do that, right? So we would have to prove, hey, I postmarked the payment this date and so on and so forth. But if it's ID theft, we have to prove you didn't take out these loans. If it's I settled this account, we have to prove you paid that settlement. The proof is always going to be in the pudding, but it's just keep the evidence, don't throw anything out, keep good notes, it will be golden. Great question.
All right. Hey, you guys, because the lawyer is here, it's 180 people in here. Congratulations to you guys who are getting all this information. If you guys can kindly hit the like button, it'll share to more people, and then more people can grab this information. I do have one more question before we bring up our next guest. Is that okay with you, Aaron?
Absolutely.
All right. It says the credit collection that garnished my check reached out, and now they're trying to get another account with garnishment of my check. So I think that's like an open-ended question, kind of.
I think what it's happening is someone's already been sued. Now their check's being garnished. Now that same agency picked up a second account, and they're coming after them for a second account. They're going to try to garnish more. I think that's what the question is asking.
Yeah, I think that is. So Sakina.
Yeah, Sakina, I see you in the comments section. You said, can I get my question answered, please? Will you write in that chat real quick if my summation was correct there? Do I have your question summarized correctly, Sakina?
Oh, by the way, you guys, if you have a debt collector that's contacting you or texting you, hit me and Dave up on Instagram. I'm gonna bring it down on the bottom, and then we'll get on a call with you guys or put you on a call with our team so we can expedite your process so you can work with Aaron and the team.
Yeah, that's a great point. So this whole new program is perfect for anyone with a debt collector coming after them. Any collections accounts, we are going to be able to help with that. We've created this 15-step program. It's got a lot of tech built into it, and those are great cases. So, I didn't hear from Sakina. So I guess let me just answer this very quickly. Garnishment has very specific rules about how much of your disposable income can come out of every paycheck. So Sakina, the answer is going to be if you validly owe this second account, and if they get another judgment against you, it's going to be a simple calculation. And they're just going to say, all right, between these two accounts now, you're allowed to, depending on the state, like in Florida, it's like 11% of your disposable income can be garnished. And there are other protections too. If you're head of household, so if you're the breadwinner or the only person making an income in a house, you can get protections against garnishment. But they can garnish as many accounts as you may owe if they get judgments against you, as long as the total amount of that garnishment is legal in that state, which is a factor of a percentage of your disposable income. So that's probably the answer to that question. Oh, she said yes, indeed. Okay, perfect.
I have a question.
So maybe they might be able to.
How can people protect themselves from this stuff like garnishments and?
Yeah, great question. So the most important thing I can tell you is don't put your head in the sand, because they can only garnish. Well, in most states, they can only garnish after they've sued you and won against you. There are very few states they can garnish, and some federal loans, like student loans, can be garnished right away that don't take lawsuits. But to protect is don't bury your head in the sand. These companies, they don't want to go to court against you. They don't, most of the time, it's not the first time you ever heard from them. They're sending you letters, they're calling you. One is if they're doing that, reach out to Mike and Dave first because we want to sue them. We don't want you to have to pay them. But to protect yourself, it's try to work out an arrangement with them. You know, if you don't actually owe it, if it's legitimately not your debt, of course, don't pay them. But if this is an old debt, if it's not past the statute of limitations, your best bet is to just negotiate the lowest amount you can as quickly as you can, because a garnishment's hard to stop. It's embarrassing. You know, it gets served on your employer. You don't have control over it. But they don't want it to get that far because then they have to pay an attorney to show up at court. They want to work with you because, again, if they take 40, 30, 45, 50%, they're still making 50 times what they paid for it sometimes. So they don't care. But to protect yourself, it's if you get to that stage, don't throw out anything, just work with them. The last thing you want is to get to a judgment. It's so hard to unwind at that point. And this is the worst part. Judgments can be reported forever on your credit report in some states. So you can't even get them all. So you want to do everything you can to not get to a judgment is the simplest answer to that question, Dave.
Okay. Before Mike asks another question. So I always talk about like the consumer reports, the credit bureaus, which is Experian, TradeReader, Equifax, has like incomplete, like it's inconsistent, like the open date last active, all that stuff is not reporting correctly. And I tell people to send a letter and tell them to update the information. I don't know or not, but most times they don't update it. Is that technically a violation? And can people technically serve the credit bureaus for not?
Yeah, that's a great question. So, you know, back when I was talking to Robin about the ways you can dispute, it has to be inaccurate, incomplete, or too old generally. Well, if they're reporting inconsistently, it has to be one of them, at least one of them have to be inaccurate, right? So one of the things we love to do on the lawyer side, and we absolutely litigate this. I sue credit bureaus for this all the time, and we serve them with federal lawsuits, Dave, because they're reporting inconsistently. If Experian is reporting an open date of this month and TransUnion and Equifax are reporting it something different, we know for 100% certainty someone is reporting inaccurately because it can't both be true, you know, if it's different months. Same thing, if they're reporting a different balance. I don't care if a balance is off by $1 on a different report. Someone has broken the law because they have reported inaccurate information. So inconsistent equals inaccurate, always, because something has to be wrong. And then what we do is we send a letter and we say, okay, Capital One, LVNB, whoever it is, here's what's being reported inconsistently between the bureaus. Fix it. What that means is they have to either make them all match, and that has to still be accurate, or they have to delete it. But they almost always just verify. Absolutely, that's a great case. Love that case. Because it's so easy. I get to say, I mean, what are they going to do when I hold up two pieces of paper with different information? You know, you don't get to tell one story to one person and another story to another. So that's a great question. Inconsistency equals inaccuracy.
Ooh, that's easy. And around.
Now, let me also give a small caveat, and this is something I want to make clear to everyone too. Not every piece of wrong information or inaccuracy will end up in litigation. There's still an analysis that has to go through, what's called materiality. That's a legal term. It's always in cases. It's in a bunch of case law. What that means is it has to be important enough. You know, the open date, that's important because your open date will often determine how long something can be reported, right? But, you know, you know how they have those payment grids on some of the reports, you know, the 60 months. If it shows no data in one of those months, probably not going to sue on that, you know, because there's 60 months there. And if it shows your on-time payments otherwise, like, that's wrong. You can dispute it. They should fix it. But if you come to me and say, hey, Aaron, they're showing a no data on this 1 month of 60 and the other 59 are right, I'm going to say, you know what, that's annoying, but that's not worthy of a lawsuit. But open date, they're reporting the date of last payment differently, the date of first delinquency differently, the past due balance, any of the big indicators, like the big important things, how long something's going to be deleted. If there's inconsistency among any of that information, it equals inaccuracy, equals lawsuit.
Oh man, that's a layup, man. I see that a lot actually.
It is, and honestly, I tell people this all the time. I could just practice with enough people if I just like set up a stand at a flea market outside the grocery store, because there was a special on 20 minutes. What's
Yes, it was 60 minutes, and
60 minutes.
yeah, it was called 100 million inaccuracies, something
Exactly,
like
100 million accuracies, and they shared a stat that 40% of people have material errors on their credit report, and then that means material errors means it is something big enough that will impact your ability to get credit, a job, an apartment. 40% of people. So that means there's 180 people on here, right? So that's 64 people. You know, probably right now, just on this Zoom, or live YouTube, have errors that are material. So 40%. And I think that number is low because these companies since then, that's about 10 years old, that CBS segment. In the last 10 years, these companies have started to embrace more technology and more artificial intelligence. And that's causing more inaccuracy. So I would say half or more. So literally, I could just set up outside the grocery store and say, hey, when's the last time you check your credit report? When's the last time you? And half the people are going to have problems. And I could just practice my law that way. But yeah.
Oh man.
My biggest thing is they don't care. That's my.
Who's the they in that sentence? The companies or the consumers or everyone?
The credit bureaus?
They don't care because here's another secret I'm going to tell you. They know they break the law and they don't care because it is cheaper for them to pay me and to pay all the consumers that sue them across the company than it is to fix. And I know that for a fact because they run those numbers. They hired actuaries and they said, all right, for us, 100 million errors, right? 100 million people in this country at that point had errors on their credit report. And they thought, all right, what would it take for us to get truly 100% accurate? And the number it would be insane. They'd have to hire tens of thousands of people. Those people would have to spend an hour on each dispute. Guess how long a dispute agent spends on average on a dispute? Mike or Dave? How long?
Like 2 seconds?
Less than a minute. Less than a minute.
Oh.
So the computers, it's instantaneous. There's no investigation. That's one computer saying to another. That takes a nanosecond. But even when they get to the overflow, so I send a 20-page letter and someone in the Philippines pulls that up, they're being timed. They're supposed to handle that in less than 60 seconds. How is that reasonable? It's not reasonable, but they don't care. Experian's litigation budget every year is $30 to $60 million. That's what at the beginning of the year, when their board of directors gets together and decide, all right, what money do we need to set aside for litigation this year? 30 to 60 million. That means that means it's more expensive than 30 to 60 million than to fix the problem. And that's every year.
Wow.
So yeah, they don't care. They're making enough money. It's cheaper for them to settle these cases than it is to fix it.
Man, that's amazing. All right.
My question is, I got a credit card company that
Dominic, what
I
state?
paid the
What
balance
state?
down to zero.
State?
South Carolina.
State.
South Carolina. All right. I paid the balance down to zero. And then I lost the card. Well, I called them to tell them that I bought a house and that I lost the card and I needed to change my address. Well, they said no problem. They would change the address. They'd send me out a new card. Well, 4 months went by. I didn't hear anything. So I called them. Said, okay, they've changed the way they do business. I have to fax them something about, a piece of mail, with a copy of my driver's license, and stuff like that. And so I faxed it. Well, I didn't hear nothing back again for a couple months. And I called in. They said, we're reviewing it. We received it, but we're reviewing it. Well, now they say they haven't received it at all. And it's been I had the account at 4 months, like 4 or 5 months when I lost the card. It's been over a year now that I haven't had the card. They've billed me everything that's on the account. It's almost $2,000 now. And it's a yearly fee and monthly fees. And that's all that's on there. And they're telling me I owe this.
Are you getting the monthly statements at all?
Because they never changed my address to my new address, but they have it. When I spoke to them this evening, that when they called, they have my new address, but they're using my previous address.
So your monthly statements are going to your previous address and they know that?
Yes.
And do you have an online portal where you can log into?
Yes.
That might be that might be the problem. So the law says if you are receiving regular statements and regular notification of what you owe, and you have a dispute with them about something else, you still have to pay it. So and the problem is if you have the ability to log in online monthly to see your account and see what your minimum payment due is, you have to pay that. Now, that's just the general rule. Because you haven't had the card, it's a little complicated, Dominic, and we might need a little bit more time on that because there's some nuanced rules here. Generally speaking, just because they haven't sent you a card doesn't mean you can stop paying them what you've had spent on the card in the past. As long as they give you either regular Dominic, you're on mute, so I know you're trying to respond, but the rule is you have to pay what you've used, so your past purchases, your past services, as long as you have the ability to see what your monthly amounts are, the monthly interest charge and how much your minimum payment is. So if you have an online access, but you're not getting statements, unfortunately, the court's going to say, sorry, Dominic, you should have kept paying. Now, if there are charges that shouldn't be there, if you lost the card and there are other charges that you don't recognize, that's a completely different story. But even if you lose the card, as long as you have access to an online account, you still have to pay for all your past purchases. And you having paid it down to zero, what are they asking you to pay now? I guess I'm a little confused then.
A monthly fee and an annual fee.
Got it. Okay.
That's all the charges that are on the card.
That's it. Just monthly and annual fee. Okay, perfect. I can help you then. Yeah, contact Mike and Dave offline, and then they'll connect you to me. I can help with that for sure.
Man, you guys are awesome. Thank you.
Yeah, that's different. Now, if you don't have access to the card, you can't enjoy the benefits of it, and you don't. Yeah, they can't keep charging you a monthly and a yearly fee, and they're not giving you access to the card because they have your address. I can help with that for sure.
Awesome. Thank you so much.
All right, Dominique. You got our information, Dominique. Just reach back out and we'll set you up.
All right. Thank you guys so much.
You're welcome. Thank
you. Hey, Dave and Mike, I think what we might have to do is break these down into like groups of 10 and maybe, might even have to charge for it or something, but there's no way with 200 plus people we can get all these questions. That hour went so quickly.
Yeah, I was kind of worried because we didn't answer nearly half the questions that's in the chat.
Yeah, not even close. But let's do this again real soon. Anyone with questions can obviously submit them to Mike and Dave. You can compile a list of ones that because you know what can be cases from our program. Yeah, you guys can be.
We have your questions. If you got my email or Instagram, we'll be able to respond, and I'll be able to ask his team if this is the case or not, and then we'll be able to see if we can assist you. Whew, man,
that was awesome. I had such a good time.
Thank you so much, Aaron.
I got you, Wayne.
Aaron, 200 people came up. You weren't shy about your answers, and I'm so glad that people got to actually listen to a real lawyer talk about credit because you don't need a license to do credit repair in some states. So It's like the wild, wild west, and people can say any and everything. But it's very important that we got somebody who can give direction for us to get compensated.
I got you, Rosemary, too.
Right. Excellent. All right, guys. Thank you so much again for the opportunity. We're going to do this again. Don't worry, everyone. Appreciate you.